Dear students, friends, I have been delivering lectures online through YouTube after my retirement. So far, I have taken up 5 subjects. I delivered so far more than 30 lectures on 5 subjects on first semester. One among these 5 subjects is family law one, that is Hindu law. In the last class, I discussed in detail about Hindu marriage, significance of Hindu marriage, what is Hindu marriage, what is the importance of Hindu marriage, what are the conditions for a valid marriage under section 5, what is the nature of Hindu marriage, whether Hindu marriage is a contract or sacrament and sacrosanct, and civil contract, or both. On these various issues, I delivered first lecture on family law, Hindu law. Now, in this lecture, I want to take up matrimonial reliefs under Hindu law. Matrimonial reliefs means what are the remedies available to the aggrieved party, wife or husband, under Hindu Marriage Act. We know our Hindu marriage has great significance and utmost importance. Basically, marriage is in our human life, marriage is the most auspicious event. It is a pious event because marriage confers social status. A man or woman without marriage claims no respect in the society. They are looked down. Don't think that a man can move without wife, but the issue is equal. How a woman is looked down in society without husband, similarly a man without wife cannot claim any importance in the society. Basically, marriage is a most auspicious and pious event in human life. In simple words, marriage is nucleus in family life. Now, in the last class, I discussed about what is marriage, what is the importance of marriage, what are the conditions necessary for validity of marriage under Hindu law, what is the nature of Hindu marriage, whether Hindu marriage is sacrament and sacrosanct or civil contract or both. If you refer to my previous lecture, you will have an idea about this. Now, in this particular class, I want to discuss about various matrimonial remedies available under section 9 to 13b of the Hindu Marriage Act. What are the various remedies mean? Section 9 speaks about restitution of conjugal rights. Restitution of conjugal rights means when a man and woman got married, each party are having rights to have consummation. You know, the very objective of marriage is dharma sampatti, praja sampatti, and rati sukham. Among the main objectives, how dharma sampatti and praja sampatti are very important, rati sukham or conjugal society, conjugal happiness also is equally important, because sexual pleasure is a biological necessity for every human being. So that is why when a man and woman got married, each party has a right to have conjugal society. In case either of the parties, whether wife or husband, leaves the other spouse in the sense, for a woman, spouse is husband, for a man, spouse is wife. If either of the spouses, whether wife or husband, leaves the matrimonial society of other spouse without any reasonable cause, then that spouse who left the matrimonial home is called deserting spouse. The person who was left alone in the matrimonial home is called deserted spouse. For example, wife and husband are there. They got married a few months back or a few days back. Wife, out of homesickness or some other reason, as she cannot adjust with the new life, leaves the husband, goes to parental home remain there for months together and in years together, and does not come back to the husband's matrimonial society. Then the wife who left the husband went to her parental home, remained there continuously, is called deserting spouse. The husband who remained in matrimonial home without wife without any reason is called deserted spouse. So here wife is wrongdoer, husband is deserted spouse, he is aggrieved party. Then the aggrieved party who lost matrimonial society for no reason, without any reasonable cause, has he is given an opportunity under Section 9 of the Hindu Marriage Act to file a petition in district court for restitution of conjugal rights. Under petition for restitution of conjugal rights, the aggrieved party or deserted spouse, husband or wife, as the case may be, can file a petition as praying the court, my wife left me and without any reasonable cause and I am alone. I request the court to give direction to my husband, to my wife or husband, what to come back to the matrimonial home. That is called, if the court, having satisfied with all the conditions therein, gives order, serves order to the respondent, then that is what is called the decree for restitution of conjugal rights. In common sense, I wish to tell you, as I told you earlier, husband and wife got married sometime a few months back or few days back, but wife left the husband and went to parental home, did not come back for so many days or so many months or even years, in spite of several requests and reminders by the husband. And then wife is called deserting spouse, husband is called deserted spouse. This deserted spouse, that is husband, can invoke the decree, can seek the decree for restitution of conjugal rights under Section 9 of the Hindu Marriage Act. For where the aggrieved party, either husband or wife, who is deserted, can file a petition under Section 9 provided some conditions are satisfied. The first condition is the marriage is a valid marriage under Section 5 of the Hindu Marriage Act. That is the first condition. Second condition, the wife, the deserting spouse, maybe a wife or husband, left the matrimonial home. But means matrimonial home means after getting married, the wife and where the home where wife and husband are living together. That is called matrimonial home. The other spouse, the respondent spouse, left the matrimonial home without any reasonable cause. That is reasonable cause. That is second ground. So provided what is reasonable cause, there is no any clarification, there is no any definition or a test. But what is reasonable cause can be decided depending upon the facts and circumstances of the case. There may be several reasons. If there is no, if wife or husband left the matrimonial home with reasonable cause, with the genuine cause, the petition for restitution of conjugal rights cannot be invoked. For example, wife got married, started living with the husband, but the husband is calling his friends regularly and taking a wine party, asking the wife to arrange water, sodas and other snacks, and his colleagues indecently behaving towards wife, she can leave the matrimonial home and go. Second, there is no then husband cannot invoke petition for restitution of conjugal rights under Section 9. Similarly, she got started living with husband after getting married, and the husband has his near or dear from his native place are coming to the started coming and staying with husband. So many people are there, so many near and dear, and husband is insisting the wife to make food and all these things, and wife is overburdened, and his husband's parents started living and harassing wife. So many problems. If the circumstances so prevail that the wife finds it very difficult to live with the husband. That is called, there is no, then she can leave, there is no any reasonable cause. So that is why when an aggrieved party wants to file a petition in district court under section 9 of the Hindu Marriage Act, some conditions are to be satisfied. Basically, firstly, the marriage should be a valid marriage under section 5 of the Hindu Marriage Act. Secondly, the respondent left the matrimonial home without any reasonable cause. So, I want to tell you one more thing. Reasonable cause in the sense, suppose there is a wife, there is a woman, she has parents, they are unable to live on their own. The woman cannot see his parents remain starved. But there is a duty, not only son has an obligation to feed the parents, but also daughter also has an obligation to feed the parents who are unable to live on their own. Suppose there is a case, the parents are unable to live on their own, the wife doing some employment and providing food to the parent for which objects, then wife takes a decision. I cannot see my parents remain starving. So if you allow my parents to stay with us, I will be comfortably stay with him. If you ask my parents, if you ask me, push my parents into streets and remain starving, I won't be able to see them starving. So for the purpose of, in order to give food to my parents, I want to go out, do some employment and feed my parents. On that pretext, wife left the matrimonial home in order to feed his old aged parents who are unable to live on their own. Then it can be treated as reasonable cause. It cannot be treated as a reason, because the Supreme Court said in some case that what constitutes reasonable cause. Not only son but also husband, not only son but also daughter is having obligation to feed his parents who are unable to live on their own. So this is the point. So section 9 of the Hindu Marriage Act speaks about restitution of conjugal rights. So when once and when a man and woman got married, they swear upon the marriage. There are two auspicious ceremonies, Homa and Saptapadi. They promise to live together, because Hindu marriage is of great importance in Hindu philosophy, because it is a pious ceremony. It is a Hindu marriage is a pious is most important occasion, most auspicious occasion. When once a man and woman got married, they promised to remain together, sharing all pleasures and pains till the end of the life. That is the significance of not only Hindu marriage but also any marriage in this universe. So any marriage in this. So this is important. Now the question is, there is practically we are witnessing some problems. If any matrimonial home, in some cases husband leaves wife and lives separately. In some case wife leaves matrimonial home and lives separately, either with parents or elsewhere due to some reason or others. So then if the aggrieved party files a case for restitution of conjugal rights, the court will take into various aspects. Whether four things. Why before giving decree for restitution of conjugal rights, the court will look into the matter whether the marriage is a valid marriage under section 5 of the Hindu Marriage Act. That is first thing. Secondly, there is a reasonable cause. There is no reason. Without any reasonable cause, the respondent left the matrimonial home. That is second condition. Third condition is there is no ground to dismiss the petition. There is no ground to dismiss the petition, and the case is filed within the jurisdiction of the court. Then the court will issue decree of restitution of conjugal rights to reciprocal conjugal rights. By that, the respondent, that is the deserting spouse, either wife or husband, as the case may be, under the decree of divorce, under the decree of restitution of conjugal rights, the deserting spouse is directed to go and join the matrimonial home. There are so many cases. Practically, what happens is in certain cases, wife and husband both are employed. Wife and husband both are employed, and wife lives in one place, husband lives in one place, but children are there. But because wife and husband are working at different places, the career of children is getting spoiled. But husband asked the wife to resign job and join matrimonial society. But wife is reluctant to resign the job. In such case, husband may file a petition against the wife for restitution of conjugal rights. In such cases, how far it is deserving, whether the decree for restitution of conjugal right can be sanctioned or not, will be decided depending upon the circumstances of the case. Depending upon the circumstances of the case. So it is not because of paucity of time, short time. Within a very short time, dear children, students nowadays, students do not have a lot of patience to listen to lectures hours together. We have to complete anything within a short span of time. So that is why within 1 hour I wish to complete so many topics. So many topics. That is why it is very difficult to go into section-wise explanation and case-wise explanation. I want to tell you one burning case. In some cases, the deserting, if there is a reasonable cause, then the decree for restitution of conjugal rights is granted. If there is no any reasonable cause, the decree for restitution of conjugal rights is not granted. But now one thing, there is a question. There are some cases where the wife is asked to resign her employment or other important profession and go and join matrimonial society. This question gave room for some controversy. Stating that Section 9 of Hindu Marriage Act violates fundamental rights guaranteed under Article 14, 19 and 17 1G. This is the question. This question came for discussion in a very leading case, Sarita versus Venkata Subbaya. Miss Sarita was a film star in Tamil and Telugu movie. In Telugu also, she is not only an actress, but also a very beautiful dubbing artist with melodious voice. You remember the children, Maro Charitra is very famous. She is a heroine for that. She is a very good dubbing artist. Now, what happened in this case was, Mrs. Sarita, film star Sarita, got married to one Mr. Venkat Subbaya of Nellore, Andhra Pradesh. Sometime after marriage, after getting married, Sarita did not live with husband and remained in Chennai. At that time, Madras. Remained in Madras, today Chennai, as she was having lot of opportunities in film industry, not only as a heroine but also as a dubbing artist, voice-over artist. Venkat Subbaya, the requester asked his wife Sarita to leave Chennai, all her commitment, and join his matrimonial society, for which Sarita refused. Then Venkat Subbaya filed a case in District Court Nellore for restitution of conjugal rights. Having taken into consideration, Nellore District Court considered that Mrs. Sarita left matrimonial home without any reasonable cause, and hence the District Court Nellore issued granted decree of restitution of conjugal rights, directing the respondent, Mrs. Sarita, to leave Madras and join Madras for Nellore to join the matrimonial society. Then Mrs. Sarita preferred appeal before Andhra Pradesh High Court. Andhra Pradesh High Court. At that time, Andhra Pradesh and Telangana were united. There was no separation of state. For entire Telangana and Andhra Pradesh, Rayalaseema, there was only one state. The apex court of the state was High Court of Andhra Pradesh. Mrs. Sarita preferred appeal before High Court of Andhra Pradesh, contending that by directing the respondent to leave Chennai for Nellore to join the matrimonial society violates the fundamental rights of the respondent, because Article 14 of Indian Constitution guarantees every citizen, irrespective of sex, race, religion, etc., equality before law and equal protection of law. So, how law protects males? Similarly, such protection should be made available to the females also. So, in the eyes of law, men and women are equal. Men and women are equal. So, second one is Article 21 of the Indian Constitution guarantees right to life and personal liberty. But at the time of Constitution, the scope of Article 21 was very limited. At that time, the protection was available against executive orders, executive action. But after Maneka Gandhi's case in 1978, the protection of under Article 21 was made available against legislative actions also. Subsequent to Maneka Gandhi's case, the scope of Article 21 is being elaborated, extended. Earlier, the protection under Article 21 was available to life and liberty. Now it is extended to so many issues, right to livelihood, right to work, right to profession, right to free environment, right to health, right to die. So many things, so many issues have been included. Now the scope of Article 21 is very wide. So, as a consequence of so many landmark judgments of the Supreme Court. Now coming to that. Now Sarita, on behalf of Sarita, it was argued that Article 14 is equal to man and woman. So why you are asking Mrs. Sarita to leave Chennai and go to Nellore? Why don't you ask the petitioner, Mr. Venkat Subbaiah, to leave Nellore and join Sarita at Madras at that time? That is one question. Secondly, Article 21 guarantees right to life and personal liberty. Every citizen is absolutely free to move anywhere in India. Anywhere in India. Whether it is Chennai or Hyderabad or Visakhapatnam or anywhere in India. Anyone can move anywhere in India without. If one can move any outside India, subject to passport and visa regulations. Subject to issue of passport by the home country, state of domicile, and foreign country by issue of visa. That is, personal liberty is available. So Sarita has opted to settle at Chennai. So if by asking Sarita leave Chennai violates her fundamental rights guaranteed under Article 21, that was the question. One more question also we can mention here. One more point also. Article 19(1)(j), Article 19(1)(g) guarantees right to take up any profession, any employment. So every individual by birth is under liberty to is under liberty to take up any profession. It is a hereditary profession or any employment or whatsoever. Everyone is at liberty to take up any profession. So these were on these grounds, P.A. Chowdhury, the then justice, the division bench headed by P.V. Chowdhury, quashed the judgment given by the Nellore High Court. after the decision of the AP High Court through P.H. Chowdhury, Justice P.H. Chowdhury, there was a lot of debate among the members of the bench and bar. So the judgment of P.H. Chowdhury in those days created a lot of, it was a viral issue in those days, because the judgment of P.H. Chowdhury, whether he delivered such judgment by out of discrimination like that, whether if it is so, what is the significance, what is the importance of Article 9 of Section 9 of the Hindu Marriage Act? The Section 9 of Hindu Marriage Act is of great importance. The main object of Section 9 is to unite the couple. It is the backbone of the matrimonial. It is Section 9 of Hindu Marriage Act is the backbone for the indissoluble union of the marriage. So it wanted to, Section 9, the purpose of Section 9 is to strengthen the matrimonial society. So basically, any court would try its best to unite the couple, but no court would try to get the couple separated. So similarly, the purpose of Section 9 is to unite the couple. It would not like to break down the matrimonial tie. So if because of the P.H. Chowdhury's judgment stating that Section 9 violates Article 14, 19 and Article 14, 21 and even 19(1)(g). So whether the crucial question that arose at the time is whether Section 9 of Hindu Marriage Act is violative of fundamental rights. So the constitutional validity of Section 9 was questioned. Subsequently, Delhi High Court, similar case, Delhi High Court did not follow the Andhra Pradesh High Court judgment and said that it gave priority to Section 9 and said that Section 9 is not violative of fundamental rights. Subsequently, Harvinder Singh versus Harmandir case, Delhi High Court judgment, the same judgment was followed by Supreme Court in Tirad Kaur's case and upheld the constitutional validity of the Section 9 of the Hindu Marriage Act. So, in view of this, Section 9 of Hindu Marriage Act is of great importance to strengthen the matrimonial tie. The purpose of Section 9 is to unite the couple and strengthen the matrimonial society, and it is not at all violative of fundamental rights guaranteed under Article 14, 19, 1(g) and 21 of the Indian Constitution. With this, Section 9 Hindu Marriage Act, restriction of conjugal rights. Question may be asked exclusively on Section 9 of the Hindu Marriage Act with reference to the constitutional validity of Section 9 with reference to Sarita case, this topic. Next, Section 10 refers to judicial separation. Before Section 9 speaks about judicial separation, Section 13 speaks about divorce. Section 13b speaks about divorce by mutual consent. So these topics we discuss in detail. So Section 9 under matrimonial remedies, Section 9 deals with restitution of conjugal rights. The purpose is to unite the couple. Section 10 speaks about judicial separation. So separation of a couple, wife and husband, through court of law for a period of 1 year. That is judicial separation. This topic we will discuss later in detail. Section 11 speaks about nullity of marriage. Section 12 deals with annulment of marriage. 13 deals with divorce. 13b deals with divorce by mutual consent. 9 is Section 10, judicial separation. Through court of law, wife and husband would be separated for a period of 1 year to check. Because divorce is not, marriage is not dissolved. Divorce is not granted directly. Judicial separation is a provisional divorce for 1 year. Provisional divorce for 1 year. Within 1 year, the wife and husband will have to realize themselves. To live together is good or to get separated is good. So within this 1 year, they will think, because most of the in marriage naturally, while getting married, the people see height, weight, color, age, and all these aspects, but they do not think about intangible attitudes and mentalities. So the minds and the mindset of husband and wife should be, wife's mind should be consistent with husband, husband's wife should be consistent with wife. Then there will be good understanding, mutual cooperation. But in so many cases, there is inconsistency of minds between wife and husband. What wife thinking is in one way, husband's thinking is in one way, in another way. They conflict each other, quarrel each other, which is quite obvious in so many cases. But now, so long as when they are living in same matrimonial home, they get an idea to get separated. But when they are separated for some time, they will realize. So then, out of hurry, out of hesitation, out of excitement and anxiety, they simply approach court. We can no more live together. We want divorce. They say no. The court simply says, don't go, don't take hasty step. Now you get separated for a period of just 1 year through judicial separation, and examine yourself, think yourself. What is find out the difference, whether living together is better or getting separated is better. You make a comparison between those days of living together and compare the present day of living alone in isolated way, and get yourself realize whether that is better or this is better, and then realize. If you feel that living together is better, you go back to matrimonial home. Still you feel that getting separated is better, then you can invoke the petition for divorce under section 13 of the Hindu Marriage Act. That is this thing. So now, before going to discuss about this judicial separation and judicial separation under section 10 of the Hindu Marriage Act, and divorce under section 13 of the Hindu Marriage Act, divorce as per divorce by mutual consent under section 13b of the Hindu Marriage Act, let us now discuss about nullity and annulment of marriage. Nullity and annulment of marriage. So in previous class I told you, in one way marriage is a sacrament and sacrosanct. In another way, marriage is a contract, civil contract. If the wife and husband are love each other, they are very more affectionate couple. They live for each other, and they remain together forever, remain together, sharing pleasures and pains. Then it is an indissoluble union. In that way, it is an indissoluble union. Then it comes under the category sacrament and sacrament. In certain cases, the wife and husband, it is just like a civil contract. We cannot have the relationship, such an auspicious, affectionate relationship between certain couples. They just get married, live together for some time. If they are not happy, they take it easy, the marriage, and get prepared to separate. That is, in such cases, it is a civil contract. So, in one way, marriage is indissoluble union, that is sacrament and sacrosanct. In other way, marriage is a civil contract if either of the parties invokes a petition for judicial separation under section 10, nullity of marriage under section 11, annulment of marriage under section 12, divorce under section 13, divorce by mutual consent under section 13b. Now, what is nullity of marriage? Nullity of marriage so how contract is a valid contract, void contract and voidable contract. Marriages also can be categorized under valid marriage, voidable marriage, and void marriage. Valid marriage means a Hindu marriage. Any Hindu marriage which is solemnized in strict compliance or adherence to the conditions or rules or principles under Section 5 of the Hindu Marriage Act, that marriage is a valid marriage. If the conditions under Section 5 are violated, suppose the marriage, the most important conditions are bigamy. Second one is restitution, one is bigamy, degrees of prohibited relationship, absence of marriage ceremony, and some important conditions are there. If that important condition is violated, if the couple got married, that marriage becomes a void marriage, and it is invalid in the eyes of law. Voidable marriage means if a marriage is solemnized against the consent, without any free consent, but by virtue of the force, by virtue of the influence of coercion, undue influence, fraud, misrepresentation, etc., that marriage is a voidable marriage. So, valid marriage is 100% valid, void marriage is 100% invalid, whereas voidable marriage is not 50% valid, 50% invalid. If the aggrieved party challenges the validity of marriage, and then it is void. It becomes void. If the aggrieved party does not challenge and keeps quiet and entertains the matrimonial society, then it becomes a valid marriage. First, we discuss about Section 11 of the Hindu Marriage Act, which speaks about nullity of marriage. What is the nullity of marriage? What is the nullity of marriage? Nullity of marriage is also known as void marriage. Now, Section 11 deals with Section 11 of the Hindu Marriage Act deals with nullity of marriage. Now, or void marriage. Now, a marriage to be valid, some conditions are to be satisfied under Section 5 of the Hindu Marriage Act. What are the conditions? Number one, monogamy. Monogamy means when a man or woman wants to get married, he or she should not have spouse living at the time of marriage. So, when a man wants to marry, he should not have wife living. And similarly, the woman should not have wife living. That means she is not married till then. Or if married, the spouse died. Then only so the monogamy means only one spouse. One means man must have only one wife, woman must have only one husband. So by the time when a man or woman wants to get married, either they should remain unmarried till then, or if married, the spouse has been dead. Spouse died long back. That condition is called monogamy. Suppose if even though the spouse is alive, his husband or wife attempts to marry again, so it amounts to bigamy under Section 17 of the Hindu Marriage Act and also Section 498 of the Indian Penal Code. That marriage is illegal. Illegal. So that marriage will be rendered void. That is. Second is restitution of degrees of prohibited relationship. Section 5 Hindu Marriage Act prescribes certain relations not to be married. So marriage between, there are some auspicious, there are some pious relations. Marriage between mother and son, marriage between father and daughter, marriage between uncle and niece, marriage between brother and sister, marriage between uncle and aunt. Like that, there are some pious relations are there. So between those relations, the marriage should not take place. So if this rule is violated and the marriage got married, the aggrieved party can file a petition for nullity of marriage under Section 11 of the Hindu Marriage Act. Next one is next important conditions for nullity of marriage is sapinda relationship. What do you mean by sapinda relationship? So in Hindu philosophy, the male son has great significance because the son is a Vamsodharaka, son is a sapindra. The concept of putra means father, son. 3 degrees in ascending order, 3 3 degrees in descending order, one becomes subpinda to us. So subpinda in the sense, the subpinda is one who has been conferred the status to offer pinda to the parted ancestor. Parted ancestor. Suppose father died first, son can offer pinda. By offering pinda pradhan, by performing this pinda pradhan, the so-called son takes the parted father, reaches the heaven. By that, the so-called son, by offering pinda, and acts as a ladder by lifting parted ancestor from hell to the heaven. That is what is. So, whoever dies first. Suppose son dies first and father is alive. Father offers pinda to son. Suppose grandson dies first because father is there, grandfather is there. Grandfather can offer pinda to the grandson. So father, son. So ascend 3 degrees in ascending order, 3 degrees in. So the relation from these 7 bloods, one female and one male should not get married. So if one male and one female got married from these 7 degrees, that amounts the subpinda relationship got violated. So by any one of these, either by violating the principle of monogamy, by violating the principles of restitution of, by violating the principles of degrees of prohibited relationship, violating the principle of subpinda, if the couple get married, that marriage is realized later. The aggrieved party can file a petition for nullity of marriage under section 11. This court, having satisfied with the condition thereon, issue the decree for nullity of the marriage. Then this marriage stands extinguished. When once the marriage got extinguished through the decree of nullity of marriage, both the parties become free, as if they are not married. They are absolutely free to get married, subject to the condition that if an appeal is not preferred. If appeal is not preferred, the pendency, if the pending appeal is cleared, then they will become free to get remarried. This is about section 11, nullity of the marriage. Next one is 12. Section 12 of Hindu Marriage Act deals with annulment of marriage. Annulment of marriage means cancellation of marriage. I told you previously voidable contract, how voidable contract is there. Similarly, voidable marriage is there. We know valid marriage means 100% valid marriage. Void marriage means 100% invalid marriage. But don't think that voidable marriage is 50% valid and 50% invalid. So, voidable marriage in the sense, in the voidable marriage is performed or solemnized, violating the principle of free consent. Violating the principle of free consent embodied under section 14 of the Indian Contract Act. When basically marriage is a contract. When parties enter into a contract, the free consent of the parties is there. So the parties should not consent to the marriage by coercion, undue influence, fraud, misrepresentation, etc. Then that marriage becomes voidable. For example, there are when a marriage is solemnized by out of flaw in consent, by coercion or misrepresentation, fraud or anything. That is against. Suppose a marriage is said to be voidable marriage if it is performed or solemnized against free consent, without any free consent of the parties, but without the free consent of one party. That is one reason. Second, at the time of marriage, one of the party, the respondent party is pregnant at the time of marriage. Third reason is the respondent party is impotent, that is unfit for conjugal relation. Next is the respondent party is unsound mind. Unsound mind. These are the 4 reasons. First one is unsoundness of mind. So in Contract Act, a marriage, a contract to be entered into, both the parties must be sound mind. They must not be insane. They must be of sound mind under Section 12 of Indian Contract Act. When two parties are there, if they want to get married, one is sound, if other one is sound, suffering from any mental disease, insane, that party is unmarried. But that if in person is misrepresented as sane person and got married, subsequently the agreed party came to know that they told me that the girl is good, but after getting married he came to know that the girl is suffering from mental disease, girl is mental. That is similarly girl did not know that boy is suffering from some mental disease, boy is insane. So this girl also can repudiate the marriage, cancel the marriage. So a marriage, the parties to marriage must be of sound mind. They must be sane. Second condition is they fructify in by virtue of one of the marriage objects Rati Sukam. Both the parties must be competent to participate in a conjugal relationship. Suppose either husband or wife is impotent, they cannot is not fit for conjugal society, then the aggrieved party can file a petition for annulment of marriage under Section 12 to repudiate or cancel the marriage. Second. Third one is pregnancy at the time of marriage. Before marriage, the girl had a sexual relationship with somebody other than the spouse, and she was pregnant at the time of marriage. But after some time, very few days after marriage, it is realized that she is pregnant. Then the husband can challenge that the pregnancy might be with somebody other than himself. Then he can challenge the cancellation of marriage, repudiation of marriage. That is something. So on these grounds, number one, insanity. Number two, impotency. Number three, fraud, free consent. Number four, pregnancy at the time of marriage. So these are on these grounds, the aggrieved party can file a petition for annulment of marriage, cancellation of marriage under Section 12. Suppose the aggrieved party does not challenge the marriage and adjusts with the circumstances, so the marriage will continue to be valid. For example, pregnancy at the time of marriage, the husband did not question, maybe due to reason that the girl is very good girl, or the girl is very propertied, or whatever may be some due to some reason or other reason which the boy likes. Then if the pregnancy of marriage, if he keeps quiet and continues, then the marriage will be allowed to be a valid marriage. So free consent in some cases, what happens is younger girl is beautiful, elder girl is not beautiful, but at the time of introduction of girl and boy, younger girl was shown in makeup, and at the time of marriage, elder girl was presented. So and due to the flowers, the bride's face was covered by flowers, as in the case of certain North Indian marriages. The boy would not able to see the face of the girl till nuptial room, first night, and then he came to know about the real face, and he challenges, no, you showed second girl and got me married to first girl, why this? I don't like to continue the marriage. Then the elders may convince him, you my child, my boy, please listen to me. Elder girl is very nice girl, very decent girl, dignified girl, number one in good conduct and character. She is a wonderful lady. She will give you, she will treat you like God, like this. But a younger girl may be beautiful. She is a mischievous girl. So if you accept the elder girl, your life will be bright. So the elders may convince the bridegroom. Then he gets convinced and keeps quiet. though the marriage played flaw in consent, fraud was played in this particular marriage, that marriage is allowed to be a valid marriage. That is annulment of marriage. So next third. Now, so far we have discussed about Section 9, restitution of conjugal rights, Section 10, judicial separation, Section 11, nullity of marriage, Section 12, annulment of marriage. Now we have to discuss about dissolution of marriage. There are the Section 10, 13 and 13b deal with dissolution of marriage. Dissolution of marriage means putting an end to matrimonial tie, closure of the marriage, extension of the marriage. Now, Hindu Marriage Act made provisions for dissolution, completion, cancellation of the marriage. There are four provisions. Section 10 speaks about judicial separation. Section 13 speaks about divorce. Section 13b speaks about divorce by mutual consent. According to Section 10, so except one reason, judicial separation is separation for only 1 year. Divorce under Section 13 is closure of marriage forever. This is only different. But before 1976 amendment to Hindu Marriage Act, the position of judicial separation, the grounds for judicial separation and divorce were different. But today, after 76 Amendment Act, what are the grounds for judicial separation? Same grounds are there for divorce also. So, both are same. The reason is, in divorce, marriage is suspended for 1 year, and divorce, marriage is dissolved forever. So, when the party, either of the party, husband or wife, wants to approach the court for cancellation of the marriage or dissolution of the marriage, in the first instance, they should file a petition for judicial separation under Section 10 of the Hindu Marriage Act. They are not allowed to file a petition for divorce directly. The reason is, out of immaturity, out of anxiety, out of anxiety or other childishness, they may come forward to get separated. But marriage is a pious and most auspicious event in human life. A man or woman without marriage doesn't have any social status. So marriage in fact is a nucleus or heart. How heart is very essential for survival of human life, and marriage also is very essential for survival to be a member for family life. That is why, according to Section 10 of the Hindu Marriage Act, there is a provision for judicial separation. If husband or wife can file a petition under Section 10 in district court for judicial separation on various grounds. Number one is, they got married 1 year back. There is a gap of from the date of marriage and presentation of a petition. The marriage is there is 1 year gap. Secondly, the marriage is valid marriage under Section 5 of the Hindu Marriage Act. Secondly, there is a gap, or there is a 1 year elapse. There is a lapse of time for 1 year. So the husband, the petitioner, either husband or wife, is unable to live with the continue to live in matrimonial home. And if on these grounds the petitioner can file a petition against the respondent, if the court will see, yes, they got married 1 year back, 1 year time period is there. Secondly, the court is competent, they got married within the jurisdiction of the court, and that condition is satisfied. So the reasons furnished by the petitioner are genuine. There is a reasonable cause. There is a reasonable cause. And then the grounds for judicial separation are mentioned. There are earlier the grounds for judicial separation and divorce were different before 76 Amendment Act. After that, both are same. So the common ground, there are common grounds. So desertion. Desertion means husband left wife without any reasonable cause, or wife left the husband without any reasonable cause. That is, desertion is one reason. Second one is adultery. Adultery means my husband started living with another woman. That is ground for separately for woman. Sorry. First one is desertion. Second one is cruelty. Cruelty in the sense my husband is ill-treating me or my wife is ill-treating me. The respondent is ill-treating. Cruelty. The cruelty is two kinds. Physical cruelty and mental cruelty. Physical cruelty means by applying force, physically harassing. Mental cruelty means without touching the body, without inflicting pains in the body, by abusive language, even by omitting to speak constitutes cruelty. So husband, the cruelty doesn't mean a physical cruelty. Suppose husband stops speaking to wife consistently, continuously, or wife stops speaking to husband consistently, also amounts to cruelty. Without speaking, how a member of the matrimonial home can continue to live in the matrimonial home. So that is why cruelty is one ground. Infectious disease. Infectious disease like leprosy, TB, AIDS, or any other disease. Leprosy, like this. So unheld for 7 years. If the respondent is whereabouts unknown for a period of 7 years, is deemed to be dead, then the petitioner can file a petition for divorce. Conversion. Conversion means we are in ours is criminal law is common to Hindus, Muslims, Christians and all, but this personal law is different to Muslims, Hindus and Hindus, Christians, Jews, etc. So Hindus are governed by Hindu law, Mohammedans are governed by Mohammedan law. Because Hindu law, according to Hindu law, monogamy is very important. But bigamy or polygamy is not allowed. For Muslims, so polygamy is allowed. Because a Muslim male can have 4 wives. So that is why there are certain cases, some Hindu husbands are professing to Islam, they are getting converted to Islam, the Mohammedan religion, and getting married second wife, third wife, fourth wife. Sarala Mudgal case is the obvious is the relevant case on this point. In that particular case, a husband professed Islam and became Muslim and got married to 4 wives, and then the matter went. The Supreme Court said in Sarla Mudgal case, means the very objective of conversion is for good purpose, right cause, not for genuine cause, not to get married so many wives and not to practice polygamy. So even though Hindu got married, after getting married, even if he gets converted to Islam, but so far as getting married, so far as to have liberty to have wives is concerned, he must continue like a Hindu, not to have more than 1 wife. Suppose after having Islam, saying that as a Mohammedan, I am entitled to marry 4 wives, and starts getting married one by one, he will not be allowed. He will be subjected to bigamy under section 498 and will be prosecuted. So this is another thing. Now there are various grounds for divorce, or any one of the grounds the petition for judicial separation can be filed. Suppose if the court takes into consideration the facts and circumstances of the case, that the petitioner's grounds are genuine, the petition should not be dismissed, and after calling for trial and hearing from both the parties, if the court comes to conclusion that the petitioner finds it difficult to continue to live in matrimonial home, can award the decree of judicial separation. When the decree for judicial separation is granted, the petitioner gets separated from matrimonial home, and the petitioner, man or woman, can live separately for 1 year. The purpose of judicial separation is to separate the couple for 1 year so as to examine themselves, so as to realize themselves. Whether prior to separation they are happy, after separation they are happy. If they come to realize that getting separated and living in isolation is a great hell, though we quarrel each other now and then, living together is better. If the deserted spouse comes to realization, and they can go back to the matrimonial home and continue like a wedded couple. Still, even after taking a judicial separation and completing the period of judicial separation of 1 year, if they feel that after judicial, the petitioner feels that living separately is more comfortable than living together, then he can invoke the petition for divorce under section 19 of the under section 13 of the Hindu Marriage Act. Now, after completion of the judicial separation, subject to the condition that there is no pendency for petition of appeal for judicial separation, subject to pendency of petition for restitution of conjugal rights, the petitioner, aggrieved party, can petition for divorce under section 13 of the Hindu Marriage Act. So we will take up this in the next class, dear friends.